This is Advocate P. Devurari from Ahmedabad, Gujarat State, Bharat. Well, my talented brothers and sisters, in our continuing journey of self-development and dignity, I am excited to present this video before all of you on this subject criminal trial, that is prosecution versus defense part 2. So today I'll be discussing about defense of accused. When the charge sheet is submitted before the Honorable Court, the learned magistrate will invite both the sides, prosecution and defense, to argue out whether the charge sheet should be accepted or not. Now, defense lawyer can find out whether there is prima facie evidence against the accused or not. If there is no prima facie evidence against the accused, then accused can be discharged. And if there is prima facie evidence against the accused, then learned magistrate will frame the charge against the accused and trial will commence. And in the beginning, prosecution will submit the evidence, prosecution evidence will be there, and defense lawyer will cross-examine the witness. Now, and then in the end, there will be examination of the witness, examination of the accused for the circumstances going against him under section 313 of CRPC. Now the latest is 351 in Bharatiya Nagrik Suraksha Sanhita 2023, section is 351. And if accused wants to appear in witness box as a defense witness and he wants to give testimony on the oath, then under section 315 CRPC, now new section 353 of Bharatiya Nagrik Suraksha Sanhita, can submit an application before the magistrate and he can give evidence on oath by appearing in the witness box. At that time, learned APD will cross-examine him and then argument will take place and thereafter judgment will be there. Now, there is thinking difference between police officer and judiciary. When police arrests the accused and sends charge sheet before the court, what is he thinking? That all men are guilty till they are proved to be innocent. This is the thinking of the police, and this is not accepted by the judiciary. What is the thinking of judiciary? Accused is innocent till he is proved guilty. This is the basic contrast between thinking of these two. Now, I'll submit thinking of cross-examination of the two greatest advocates of the century, one from England, one from America. Sir Charles Russell was the most successful cross-examination of modern time in England. Russell was the biggest advocate of the century. It has been said that his success in cross-examination was due to his force of character. What was the maxim of Russell? Russell's maxim for cross-examination was, go straight at the witness and the point. Russell produced the same effect on a witness that a cobra produced on a rabbit. Because of this reason, he was the most successful lawyer of the 20th century in the world, not only in England. Then comes American advocate, Churchill. He was called the wizard of the courtroom. He employed an entirely different method in his cross-examination. He would ask only a few telling questions, very few questions, but generally every one of them was fired point blank. His motto was, never cross-examine any more than is absolutely necessary. If you don't break your witness, then witness will break you. This was his philosophy, and that is why he was the most successful lawyer in 20th century. Now, Paul Brown's golden rules for cross-examination are discussed a few points. Number one, except in different matters, never take your eye from that of the witness. This is a channel of communication from mind to mind, the loss of which nothing can compensate. You must concentrate your eye on the witness. Next, be mild with the mild, shrewd with the crafty, merciful to the young, rough to the ruffian, and a thunderbolt to the liar. But in all this, never be unmindful of your dignity. Next, be careful that you do not lose your temper, because anger is always either the precursor or evidence of a sure defeat in even intellectual conflict. If you lose your temper, then defeat is certain for you. It is assured. Never undervalue your adversary, but stand steadily upon your guard. The most important point now, be respectful to the court. You must maintain court decorum and be kind to your colleague. Now, in new Bharatiya Saksha Adhiniyam 2023, this is replaced by the Evidence Act 1872. Now, the definition of document is expanded. Now, I'll discuss 5 points. Now, digital records. Bharatiya Saksha Adhiniyam, in short, I will say BSA. BSA expands the definition of documents to include what are included as document: electronic or digital records, email, server logs, computers, smartphones, laptops, SMS, websites, locational evidence, mails, messages on devices. All these are included in the definition of document in new law BSA. Then comes video tapping. In addition, video tapping of the search and seizure process has been made mandatory in order for the evidence to be admissible in court and prevent innocent from being implicated wrongly. The video tapping is compulsory mandatory. Victim statements in case of sexual abuse is mandatory. And video recording would be essential for sexual harassment case. Look at these things. In sexual abuse, there has to be a statement of the victim, and video recording would be essential for sexual harassment. In sexual harassment, there should be video recording. Collection of forensic evidence. Crime scenes in those offences punishable 7 years or more will now require to have forensic team present in order for police to call for scientific evidence. For collecting scientific forensic evidence for the cases, for the offences beyond 7 years punishment, there has to be a forensic team present, and this will reduce the pendency of the case. And the last point I'm discussing, one, you should lend your ears because these can affect to anybody. Stricter punishment and safeguarding women and children. For the first time, sexual intercourse under the pretext of marriage, employment, promotion, and false identity has been made punishable offence in the provision for 20 years of imprisonment and life imprisonment in the case of gang rape. अगर आप कोઈને એમ કહો કે હું તને મેરેજ તારી જોડે મેરેજ કરીશ અને ઇન્ટરકોર્સ કરો અને પછી ના પાડો 20 વર્ષની સજા, તો હું તને પ્રમોશન અપાઈશ, ક્લાર્કમાંથી મેનેજર બનાવી દઈશ અને ના આપો, ચીટિંગ માટે જ કર્યું હોય, સેક્સ્યુઅલ ઇન્ટરકોર્સ માટે જ કર્યું હોય, 20 વર્ષની સજા. એમ્પ્લોયમેન્ટ, નોકરી માટે કે ફોલ્સ આઈડેન્ટિટી માટે તમે કર્યું હોય તો પણ 20 વર્ષની સજા નક્કી માનવાનું. એટલે this is the most important thing which everyone should bother about it. And hope you got some good information from this video. This is a very interesting video, and I'll appear in the next video with some good news. This video is beyond amazing. Together we have cultivated life of self-esteem and wisdom. Thank you, thank you, thank you.